Good afternoon, students. Today is Tuesday, 22 February 2022. This will be our next to last recorded lecture for the semester. It's been a strange semester. First of all, we had orders from the administration to go online for several weeks. And then I tested positive for COVID a couple of weeks ago. And so I think to be safe, we're going to go back in the classroom, not today and not 2 days from now, but a week from today, 1st of March. Okay, let's take a look at the postings that I have put up for you on Canvas. First of all, the exam is now in the books, the first of 3 exams. I prepared a short handout for you and posted it. It's entitled Notes and Statistics on the First Examination. So you can take a look at that and see how you did in relation to the others in the class. In general, you did very well. I attribute that to, the fact that I gave you my lecture notes, the fact that I posted sample exam questions. And by the way, all of them showed up on the exam. So you had free points for this exam. But remember, you will not have free points of that type on either of the other 2 exams. So now you've taken one of my exams, you know what to expect. Also, I think the video format is useful in that you can go back and watch it more than once. If I were lecturing in the classroom, that would not be possible. So all of those things, plus a number of you are juniors and seniors, you've been around for a while, and you know how to take exams. So good job, I applaud you. Keep up the good work. The second exam is several weeks away, so don't even worry about that for the time being. Just keep up your good habits, and when the exam rolls around, you can pick it up a little bit as far as your studying is concerned. Okay, I've got something on the screen here I want to get rid of. Okay. What else have I posted on Canvas? I have posted the article, or actually the legal opinion for today and for the next 2 class periods. It's the Supreme Court case Cohen versus California. It's 50 years old right now. This case was decided on the 7th of June, 1971. So a few months from now, it'll be 51 years old, which means right now it's 50. So a nice round number. I guess that's called the semi-centennial. Semi means half. So it's half a century old. The second item that I've posted are my lecture notes for this case. That's now posted. You can follow along as I lecture. I also posted an article published in a law review written by a man named Thomas Crattenmaker. Crattenmaker was the author of this opinion, believe it or not. At the time, he was a law clerk for Supreme Court Justice Harlan, and Justice Harlan asked Crattenmaker, his law clerk, to draft the opinion, which he did. And in this article, he explains some of the details. He says that Justice Harlan was so happy with his opinion that he made only a couple of minor changes. So you could say that even though this opinion is credited to John Marshall Harlan, the Supreme Court Justice, technically he didn't even write it. His law clerk did. So that is optional reading. If you want to read that, feel free to do so. I recommend it. I think you'll find it interesting, especially if you plan to go to law school. You can see what it's like to be a clerk for a judge. The next item that I have posted is a very short essay on what's called the incorporation doctrine. It's by a man named Hudson, and I'll refer to that in a few minutes during my lecture. And the final item that's posted so far is a co-authored piece by 2 very prominent law professors, Jeffrey Stone and Eugene Volokh. The title is Freedom of Speech and the Press. So here's my copy of the very short article by David Hudson on the 14th Amendment and the incorporation doctrine. And here is the co-authored essay on freedom of speech in the press by two law professors. Okay, and we'll say more about them as we go along. So that's what's posted currently. I intend to post at least one more item, probably today, a very short piece called Whatever Happened to Cohen, of Cohen versus California. Okay, so one more item at least before we move on to the next item on the list. Remember, I am going live a week from today. There will be no more recorded videos after Thursday this week. So, what happens if you miss a class? The same thing that has always happened in all of my 30-odd years here at UTA. If you miss a class, you have to get notes from another student. That's the only recourse you have starting a week from today. So make sure you come to class. Now, I'm going to continue posting my lecture notes for all of the remaining readings in the course. If you want, it's entirely up to you. You could forego attending my live lectures and simply rely upon my posted lecture notes. I don't recommend it. I'm not encouraging you to do it, but it won't hurt you as far as your grade in the sense that I don't require attendance. So not coming to class won't hurt your grade. Of course, not coming to class could indirectly hurt your grade because you might not learn as much. If you're going only by my lecture notes that I post, you might not learn as much as if you had been in class listening to me lecture live. But again, that's your choice. You can do what you want. And so by Thursday's lecture, please make sure you've read the entire case. Maybe you've read only a part of it by now, half of it, let's say. By Thursday, by the time you turn on my lecture, make sure you've read the entire case. Okay, so let's get started. I'll cover about a third of my lecture notes today. In fact, I can tell you my plan, my hope, is to get to page 4 of my lecture notes where you'll see the section entitled Categories, Classes of Unprotected Speech. So we've got a lot of ground to cover. Let's get started and try to cover it all today. By the way, all of the page references in my lecture notes are to this official version. Now, this case has been republished many times in many different formats, and the page numbers will differ, obviously. But this is the opinion from the official United States reports, and so I'm going to use it for my page numbers, my page references. And this is the one that's posted on Canvas for you. Okay, this case, even though it's 50 years old now, it's an important case. It's still good law. It has never been overruled, even in part. Here's what a prominent law professor said about it a few decades ago. In fact, about a decade after the opinion was handed down. Daniel Farber wrote, "Today," and he's referring to 1980, "today, Cohen versus California is widely recognized as an important First Amendment case." So what we're reading and discussing today, starting today, is an important case. You'll probably see a reference to it at some point later in your life, and you'll remember, I hope, that you had read it and discussed it and understood it. Notice the title of Farber's article. The title is Civilizing Public Discourse, an essay on Professor Bickel, Justice Harlan, and the enduring significance of Cohen versus California. So not only does he say it's an important First Amendment case, but he says it has enduring significance. The court has never overruled it and probably will not. I can't imagine the court ever changing its mind on this issue, the issue that's involved in this case. Now, what's the disposition of the case? I've listed in my lecture notes all 9 of the justices who were on the court at the time. 5 of the 9 justices voted to reverse Cohen's state court conviction. A man named Robert Paul Cohen was convicted, as you will see, of violating a California statute. And he appealed. The case was initially in the California state court system, and he kept losing all the way to the California Supreme Court. And at that point, he leapt into the federal court system, and the United States Supreme Court agreed to hear the case. So 5 of the 9 justices, which is a majority, voted to reverse his conviction, which means he goes free and he is no longer punishable. 4 of the justices, the other 4, voted to remand the case. They wanted to send the case back down to the California courts for further consideration. Now, they didn't vote to affirm. They voted to just send the case back. They didn't want to hear the case. 3 of the 4, if you read their opinions carefully, 3 of the 4 would have voted to affirm the convictions. They thought that the California law was constitutional and that it covered Cohen's conduct and that the jury verdict of guilty should stand. 1 of the 4 justices, Justice White, did not vote to affirm. He pretty clearly did not want to affirm or reverse. He just wanted to get rid of it, send it back to the California courts to handle it. And one reason the 4 minority justices wanted to send it back to the courts is that the California courts, since the case had been appealed to the U.S. Supreme Court, the California courts had interpreted the statute under which Cohen was convicted. And so 4 of the justices said, look, we probably shouldn't decide this case. Let's just send it back to the California courts, and they will probably reverse Cohen's conviction because they have reinterpreted the statute. So those 4 justices just didn't want to make new law. They did not want to hold that the Constitution protects the utterance of the words that were on Cohen's jacket. And we'll talk about what those words were in due course. We don't need to talk about that right now. Now, I'm going to give you some background, philosophical and legal, and a little bit of historical background on this case. And my purpose in doing so is to help you understand what was involved. So I'm going to put this case in context. And in a way, I'm perfectly suited for this task because not only do I have a bachelor's degree in political science, but I have a master's degree in history. I have a law degree and practiced law briefly, and I have 2 degrees in philosophy, a master's degree and a PhD. So when I say I'm giving you philosophical background, historical background, and legal background, I have expertise in all 3 of those areas. So listen carefully as I go through this. Some of it will be unfamiliar to you. Some will be familiar. I hope a lot of it is familiar because that would tell me that you've had a good education. You know your history. You know a little bit about civics and about our legal system and our political system. So let's begin with something pretty basic, and that is the First Amendment of the United States Constitution. Now, the Constitution was ratified without what we now call the Bill of Rights. The first 10 amendments of the Constitution, which were added at various points after the ratification of the Constitution, are known, once again, as the Bill of Rights. And the first of those 10 is called the First Amendment, for obvious reasons. Now, the fact that it's listed first doesn't necessarily mean that it's the most important, although there are people who have argued that it is the most important amendment. I don't think they've inferred that from the fact that it's the first one listed. At any rate, the First Amendment was ratified and became part of the Constitution on the 21st of June, 1788. And that's when the state of New Hampshire became the 9th state to ratify it. In order for an amendment to take effect, 9 of the 13 states had to ratify, and New Hampshire became the 9th state on that date. So that was a glorious day because now the Constitution has been amended for the first time. And that's 233 years ago. The First Amendment is almost 234 years old. It will be in June this year. So let's read the First Amendment, and then we'll talk about it. We'll parse it. Here is the wording of the First Amendment, and it's never been altered or amended in any way. It goes like this: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And then there's a semicolon. It goes on to say, or abridging the freedom of speech or of the press. And then there's another semicolon. Or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So the First Amendment, by its own terms, says here are some things Congress cannot do. Now, the word Congress means the House of Representatives and the Senate. Those two bodies collectively are the Congress of the federal government, of the United States government. And what the First Amendment does is limit what that body, namely Congress, can do. And there's a lot in here. One thing that Congress can't do is make no law respecting an establishment of religion. Now, that could have been worded more clearly, and there's been a lot of debate about what exactly that means. Most people take that to mean something like this: Congress cannot establish a religion, a state religion. Congress cannot say, for example, that Christianity is the state religion, the religion of this country. The First Amendment says Congress can't do such a thing. Also, Congress can make no law prohibiting the free exercise of religion. People have the right to exercise their religion if they have a religion. If they have no religion, they have nothing that needs to be exercised. So Congress cannot tell people they can't pray or meet or worship together. That's pretty clearly implied by the meaning of this clause. All right, next, Congress shall make no law abridging the freedom of speech. Abridge means to cut short or truncate. It can't take away or destroy. So people have the freedom to speak according to the First Amendment, and Congress can't abridge it. They can't take it away. There's also a right of the press, and Congress cannot make a law that abridges that right either. Right? The press would include, at the time this amendment was ratified, it would include newspapers and other publications. But now, of course, we have electronic media, we have television, radio, the internet, and so on. So this First Amendment has been interpreted by courts to apply to all types of press of different forms, different media. All right, the First Amendment also says Congress shall make no law, it says Congress shall make no law abridging the right of the people peaceably to assemble. So if people want to go to Washington and protest or march or conduct a parade, and it doesn't have to be Washington, it can be anywhere in this country, the First Amendment grants a right to do so and says Congress cannot abridge that right to assemble, to get together with other people, other like-minded people, to speak, to mill about, to protest, and so on. And finally, Congress shall make no law abridging the freedom of the right to petition the government for a redress of grievances. So people have a right to complain to their government about the government, right? To try to change the law. All right? If you have a grievance, if you think a particular law is unjust, you have a right under the First Amendment to petition the government for redress, to change the law or to change how that law is applied. So the First Amendment incorporates a great many rights. Only one of them is involved in this case, Cohen. And that, of course, is the right to freedom of speech. This is a free speech case. It's got nothing to do with religion. It's got nothing to do with the right to assemble or any of the other rights we just talked about. Now, these clauses, the various clauses of the First Amendment, have been given names, and I put them in my notes. The clauses are called the Establishment Clause, the Free Exercise Clause, the Free Speech Clause, the Free Press Clause, the Assembly Clause, and the Petition Clause. So lawyers and law professors refer to these various clauses by these names. And so you might get an article about the Petition Clause, for example, or maybe a whole book. Okay, so that's the First Amendment, and you can see how it's involved in this case. There are, of course, other amendments. There are 9 other ones that combine with the First Amendment to create what we call the Bill of Rights. And then there have been a number of other amendments, 27 in all, although there has been no constitutional amendment for several decades. There probably will be another one at some point. I don't know what the topic will be, but when the people get agitated about something, and it seems very important to many people, the process of constitutional amendment can start, and the hope is that it will culminate in a new amendment added to the Constitution. Okay? So now let's talk about the 14th Amendment. As you know, we had a great and terrible civil war near the middle of the 19th century. After the war ended, the Congress of the United States met to amend the Constitution to ensure that the newly freed slaves in the South would not have their rights violated by their own states, the southern states. There were people in the South who, having lost the war, wanted to re-implement slavery, perhaps not formally, but de facto. They wanted to deprive the newly freed slaves of various civil rights so that they had no real recourse except to work for white plantation owners and others. And so Congress, seeing the problem, decided to amend the Constitution, and Congress used the formal amendment process to do this. There was a series of amendments following the war that have come to be known as the Reconstruction Amendments, and they're usually considered to be the 13th, 14th, and 15th Amendments. Notice that comes after the Bill of Rights. Okay? The 13th Amendment, which was ratified in 1865, the same year the war ended, simply abolishes slavery and also involuntary servitude. So the Constitution was amended to prohibit slavery. Never again in this country's history would slavery be allowed in any of the states, nor would involuntary servitude be allowed. So the 13th Amendment is very important and quite famous. The 14th Amendment was ratified 3 years later in 1868, and I'm going to talk about that in a moment. The 15th Amendment was ratified in 1870, and what that does is it prohibits states from restricting the vote on the basis of race or skin color or previous condition of servitude. So the purpose of the 15th Amendment was to ensure that the newly freed slaves, indeed all black men, would be allowed to vote. Now you may be wondering, why did I say black men? Well, no women, not even white women, were allowed to vote at this time. It was not until 1920 before women in general secured the right to vote. So interestingly enough, for a 50-year period in our country's history, 1870 to 1920, the only people who could vote were white men and black men. Finally, in 1920, women in general secured the right to vote. So black women and white women were allowed for the first time to vote in 1920. And we celebrated the centennial of women's suffrage just a couple of years ago in 2020. the year 2020. Okay, let's go back to the 14th Amendment. The 14th Amendment is longer than the 13th or the 15th. The purpose of the 14th Amendment was to make it very clear that the newly freed slaves in the South, primarily in the South, but also all over the country, would not have their civil rights violated by their own states, some of which would have been happy to implement some kind of de facto slavery or servitude. So let me read to you Section 1 of the 14th Amendment. Again, it was ratified in 1868. And I think you can see as I read it that the concern was to see that the newly freed slaves would not have their civil rights violated by their own states. Here's how it reads. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So the first period, there's a period. So the first sentence of the first section of the 14th Amendment just states, if you are born or naturalized anywhere in the United States, you are a citizen of two different things, the United States and the state wherein you reside. If you reside in Alabama, you are a citizen of Alabama. If you reside in Georgia, you are a citizen of Georgia. And you always are a citizen of the United States if you were born or naturalized anywhere in the United States. Okay, so that simply declares that whether you're white or black, whether you were or were not a slave, you are a citizen of both the United States and the state in which you reside. Now, the next sentence, which is part of a longer clause, I have italicized. And it's because many people think that this part of the 14th Amendment incorporates the rights that are listed in the First Amendment. So here's what it says. No state in this country shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Semicolon. Now let me stop right there. That's pretty clear. That says to every citizen of every state, you have protection under this amendment from your own state. Your own state may have designs on your liberty and your immunities and your privileges, but this provision of the 14th Amendment says your states cannot take away any of your privileges, any of your immunities, any of your liberties, rights, and so on. Although it specifically mentions only privileges or immunities, clearly it covers liberties, rights, and things like that as well. You could say that those are encompassed by the word privileges. All right? And it goes on to say, nor shall any state deprive any person of life, liberty, or property without due process of law. Semicolon. Now, that contemplates that in a court of law, you may be deprived of life, of your life. You may be put to death for committing murder, for example. You may be deprived of your liberty, meaning you may be incarcerated if you've committed a crime that calls for that punishment. You may even have your property taken from you by the state by way of a fine or a forfeiture. So this clause says you may be deprived of these things, but only if there has been due process of law. We live in a nation of laws. The law must be complied with before you lose your life, your liberty, or your property. That's come to be known as the due process clause. We don't want agents of the state just to come to your place and take your property. First, there has to be a trial, and it has to be a real trial, not a sham trial. And when all the procedures are complied with, if the verdict is that you shall be punished by losing your property or your liberty or your life, then that would be acceptable. But there has to be due process. The procedures must be complied with before you lose those things. And finally, this is a very important part of the 14th Amendment. No state shall deny to any person within its jurisdiction the equal protection of the laws. Notice, it doesn't say any citizen, any person. So if there's within the within the boundaries of the state, let's say Alabama or Texas, if there's a person there, it could be somebody visiting from another state or someone from another country. Anybody who's within the jurisdiction of that state must not be deprived of equal protection of the laws. No second-class citizens. The laws apply equally to everyone, unless there's a relevant difference between them, and there may well be. But assuming there's no relevant difference, the law must be applied equally. That's true for rich and poor, black and white, old and young, men and women, and so on. That clause of the 14th Amendment has been used many, many times since this amendment was ratified and became part of the Constitution. Now, the clauses that I've just read to you have names, and here they are. The first clause I read is called the Citizenship Clause. The second one is the Privileges or Immunities Clause. The third one is the Due Process Clause, and the fourth one is the Equal Protection Clause. Now, this case that we're talking about involves the Due Process Clause. Arguably, it should involve the Privileges or Immunities Clause as well. It does not invoke the Equal Protection Clause or the Citizenship Clause. And you'll see how this works as we go along. Okay, you still with me? I want to talk now about the doctrine of incorporation. Incorporation. It's a doctrine you may never have heard of. You may rarely, if ever, have seen or heard that word spoken. So, let's begin with some definitions. If you look up the word incorporate in a regular dictionary, not a law dictionary, but a regular dictionary, you're likely to find something like this, which I found in my dictionary. Incorporate, when used as a verb, means the following. Quote, take in or contain something as part of a whole. Include. So if you want a synonym for incorporate, you could use the word includes. To say that A incorporates B is to say A includes B. It's to say that B is part of A. It's part of the whole that makes up A. Okay? That's a general meaning of the word incorporate. For example, when I prepared my syllabus, in fact, go to my syllabus. Go to my syllabus, I'm looking for my copy, and you will see on page 2 of my syllabus, near the top, under the heading Course Materials, I write the following. Each student is responsible for locating and printing these materials. Parenthesis. See the document entitled Reading List for details. It is incorporated herein by reference, period, close parentheses. So what I'm saying is the separate document that I call reading list is incorporated in the syllabus. It's included in the syllabus. That's what I meant by that. So what I'm doing there is using the word incorporate in its standard meaning. Now let's look at the legal meaning. This is from a legal dictionary, a law dictionary. The word incorporate means the following in the law. Quote, when used in a document in reference to another writing, it, meaning the word incorporate, means that the writing referred to is incorporated into or adopted and made part of the document. And that's exactly what I did in my syllabus, didn't I? I referred to another document And then I said, that document is included in or is made part of this one. Okay, so that happens sometimes in the law. So here's the question. When the 14th Amendment talks about certain rights that are possessed by citizens or persons, the question is, does it incorporate the rights that are listed in the First Amendment? Let me put that in a different way. Does the 14th Amendment incorporate the First Amendment? Does it include the rights that are spelled out in the First Amendment? Now here I'll direct your attention to that short article by David Hudson. This is my copy of that article. It's 3 pages long. I copied on front and back. Now, you should read this over carefully. It discusses what I'm now discussing on my video. You'll notice that on the 3rd page, Hudson has over here a list of the parts of the First Amendment that have been incorporated into the 14th Amendment. Right? And so Hudson is doing a service for you. He is a lawyer, and he has studied this matter thoroughly, and he has noticed that the courts, such as the U.S. Supreme Court, have over the years incorporated various First Amendment rights. In fact, not just First Amendment, but rights that are in the Bill of Rights anywhere, the first 10 amendments. And he has listed not only which right specifically has been incorporated and the case in which the incorporation was carried out or completed. So it's a very handy list that Hudson provides. So I'd like you to read that. I mentioned in my notes, have the students read Hudson. Now here's an interesting question. Let's go back. We know that the court has ruled over the years that various rights contained in the Bill of Rights are incorporated into the 14th Amendment. But we can ask the philosophical question, as though none of this had been done. Does the 14th Amendment incorporate the Bill of Rights? Yes or no? If you answer yes to that question, then what you're saying is that the right in question applies to the states and not just to the federal government. You understand what I'm saying? Let's go back to the First Amendment. Who is limited, specifically by name, who is limited by the First Amendment? What's the first word of the First Amendment? Congress. Not the president, not the courts, not some government agency, not the federal government as a whole, but Congress. So the First Amendment was concerned about Congress, consisting of the House of Representatives and the Senate, limiting people's rights. Now, I can tell you that over the years, the Supreme Court has ruled that the term Congress applies also to any branch of the federal government. Not just the legislative branch or Congress, but the executive branch with all of its agencies and the judicial branch. So the word Congress has in effect been interpreted as the federal government. The federal government can't do this, that, and this other thing. That's the way the First Amendment has been read. But what about the states? The states are not part of the federal government. They are distinct entities within our federal system. So the philosophical question is, does the First Amendment limit what states can do, what Texas can do, what Michigan can do, Florida, Oregon? Does the First Amendment limit what states can do to their citizens? And the court has had to answer that question. It's a yes or no question. If you look near the bottom of my page 2 on my lecture notes, you'll see that I prepared a flow chart for you. Let's start at the top and work our way down. The first question is at the very top. does the 14th Amendment incorporate or embody or take in the Bill of Rights, thereby making those rights applicable to the states and subdivisions thereof? What I mean by that is within each state there are various subdivisions, counties, cities. These are incorporated entities. They're incorporated by the state under state law. Cities, counties, entities like that, townships, and so forth. So, does the 14th Amendment incorporate the Bill of Rights? Yes or no? Early on in this country's history, in 1833, the court answered no. In the case of Barron versus Baltimore, 1833, the Supreme Court said no. The 14th, wait a minute. There was no 14th Amendment at that time, but the court said in that case that the Bill of Rights applies only to the federal government. It wasn't talking about the 14th Amendment, obviously, because there was no 14th Amendment. So let me retract what I mistakenly said. What the court ruled in 1833 is that the Bill of Rights applies only to the federal government. It didn't, of course, mention the 14th Amendment. Now, what if the answer to that question is yes? And that's eventually the answer that the court started giving. If the 14th Amendment incorporates the Bill of Rights, the question then becomes, does it do so all at once in one fell swoop, or does it do it piecemeal, one right at a time? So these are called, these two views have names. There's the total incorporation view, and there's the selective incorporation view. Now, someone who has held the total view is a Supreme Court justice named Hugo Black. Hugo Black, who I believe was from Alabama, served on the court for many years. Hugo Black interpreted the Constitution as incorporating all of the Bill of Rights, all at once. In Black's view, every right contained in the Bill of Rights applies equally to the federal government and to the states. Now, that view has not been widely shared. Hugo Black held it, maybe a few others have held it, but it's not the view that the court itself adopted. The court has adopted what's called selective incorporation. So if you look at the middle column of my handout, here's what that means. Selective incorporation says that the Supreme Court will rule case by case on whether a particular right contained in the Bill of Rights applies to the states. And one of the nice things about the Hudson article is that he has gone through and listed all of the rights that the court has actually incorporated. You can see it's quite a long list. In fact, the list is being added to. Just 3 years ago, in a case called Timms versus Indiana, 2019, the U.S. Supreme Court ruled that the excessive fines clause of the 8th Amendment is applicable to the states. So as of just 3 years ago, a new right contained in the Bill of Rights, the 8th Amendment in particular, has been held by the court to apply to the states and not just to the federal government. Well, that was a very interesting development. When I heard about it, I read it, I ran out and got the case. Well, I got it off the internet, but I went and got it as quickly as I could and read it, and it's very interesting. The court is still in the process of selectively incorporating various rights. Now, here's the next question. Which rights are to be incorporated and why? They haven't all been incorporated. Many have, not all have. So here's the test that Justice Ruth Bader Ginsburg laid out in that case I just mentioned, Timms versus Indiana, 3 years ago. Justice Ginsburg wrote the following, and you can read it at the very bottom of my page 2 of my lecture notes. She said, a Bill of Rights protection is incorporated if it is fundamental to our scheme of ordered liberty, or deeply rooted in this nation's history and tradition. So that's a particular test. And in this case, 3 years ago, the court ruled that the right not to have excessive bail imposed is fundamental to our scheme of ordered liberty, and it's also deeply rooted in this nation's history and tradition. The court therefore ruled that the excessive bail clause of the Eighth Amendment is applicable to the states, like Indiana, and not just to the federal government. So from that point forward, no state in this country, including Texas, can impose excessive bail on one of its citizens or any resident. So it's interesting, other rights in the Bill of Rights may eventually get incorporated. We've seen quite a few that have, some have not, and 3 years ago, the latest one was incorporated. Okay, now, not to get too deep into the weeds, but law professors have, and judges and lawyers have wondered which clause in particular in the 14th Amendment does the incorporating. If you remember, a few minutes ago I listed 4 distinct clauses of the 14th Amendment: the Citizenship Clause, the Privileges or Immunities Clause, the Due Process Clause, and the Equal Protection Clause. Now, only 2 of them have been singled out as doing the incorporating. The main one has been the Due Process Clause, and that's the one Justice Ginsburg and her colleagues used 3 years ago. What they said is that the Due Process Clause of the 14th Amendment incorporates certain rights contained in the Bill of Rights and makes them applicable to the states. Now, 2 of the current justices think that that's a mistake. Justices Gorsuch, Neil Gorsuch, and Clarence Thomas both believe that the correct provision of the 14th Amendment that does the incorporating is the Privileges or Immunities Clause. And they argue that in the case of Timms versus Indiana. They say that it was a mistake to ever use the Due Process Clause to do the incorporating. And the court should kind of clean up its mess. Justices Gorsuch and Thomas hope that one day the court will rule that all of the incorporated rights are incorporated by virtue of the Privileges or Immunities Clause, not the Due Process Clause. And you may wonder, why does it matter? Why does it matter which clause in particular does the incorporating? Well, Justice Gorsuch and Justice Thomas are sticklers for correct interpretations. They have read the history of the 14th Amendment, and they believe that the court should get it right. And in their view, the correct clause for doing the incorporating is Privileges or Immunities. Unfortunately for them, the court ruled back in 1873 that the Privileges or Immunities Clause could not be used to incorporate the Bill of Rights. So if Justices Gorsuch and Thomas are ever to get their way, they first have to get 3 more votes on the court to make a majority of 5, and those 5 would have to overrule that case in 1873. It's called the Slaughterhouse Cases, by the way. The court would have to overrule that case because that case very clearly says that the Privileges or Immunities Clause of the 14th Amendment does not incorporate any of the Bill of Rights. So Gorsuch and Thomas are purists. They're often called originalists. They want to interpret the Constitution in the way that it would have been understood by those who debated it and drafted it and eventually ratified it. They say that the meaning of the Constitution depends upon how it was understood back in the day, back when it was ratified. And so they hope one day to kind of clean up this mess and stop using the due process clause to incorporate. All right, let's talk, before we leave the topic of incorporation, let me ask you in particular, which case specifically and in what year did the court rule that the First Amendment right to freedom of speech became applicable to the states? The answer is in 1925, almost a century ago, in a case called Gitlow versus New York. That's when the court ruled that the First Amendment right to speak applies to the states and to all of the states' subdivisions, like cities and counties, as well as the federal government. Now let's see whether that appears on Hudson's list. I'm sure it does. If you look at Hudson's list on the third page of his article, look under First Amendment, you'll see he has a list of all of the rights contained in the First Amendment that have been incorporated. In fact, all of them have. All 6 of the clauses that I mentioned earlier contained in the First Amendment, all 6 of them have now been incorporated and made applicable to the states. The Establishment Clause was incorporated in 1947. The Free Exercise Clause was incorporated in 1940. The Free Speech Clause was incorporated in 1925 in Gitlow versus New York. The Freedom of the Press Clause was incorporated in 2 different cases, Gitlow, and then again 6 years later in a case called Neer versus Minnesota. The right to freedom of assembly was incorporated in 1937, and the right to freedom of petition was incorporated in 1963. So all 6 of those rights were incorporated in a 38-year period between 1925 and 1963. All right, so the First Amendment is completely now, as of today, all of the rights specified in the First Amendment are applicable to the federal government, all 3 branches, legislative, executive, and judicial, and all 50 states. Okay, so everyone in this country has all of these First Amendment rights. You have them not only against the federal government, but against your own state government. So it's pretty airtight. Okay, so that list by Hudson is quite useful. You may have noticed that I added, can you see up, I'll hold this up here. I added, right over here, I added Timms versus Indiana, 2019, to the list, just for my own purposes. You can add it, if you printed Hudson out, you can add it yourself. Put it under the 8th Amendment. The 8th Amendment contains the following 3 rights. According to the 8th Amendment, you have a right not to have excessive bail imposed. You have a right not to have cruel and unusual punishment inflicted on you. And you have a right not to have excessive fines imposed on you. By the way, I now realize I misspoke at least once today. When I was discussing this 2019 case of Timms versus Indiana, it's an excessive fines case. And I think I said excessive bail. If I did, strike it from the record and replace it with excessive fines. The man in that case was fined a great deal of money, and the court ruled that that was excessive. And the state of Indiana said, wait a minute, that provision of the 8th Amendment doesn't apply to us. And the court said, now it does, because we're making it applicable to the states in this case 3 years ago. Okay, we're almost done. We're less than an hour in. Probably in about 15 or 20 minutes we'll be done for the day. Let's now talk about the concept of state action. Some of you may know this, but I suspect that some of you don't. The First Amendment and the 14th Amendment as well, since it incorporates many of the rights contained it incorporates all of the rights contained in the First Amendment. The First and 14th Amendments apply only to state actors, not to private citizens or private entities like business corporations. Now here, I'm going to read a little bit from this short article by the two law professors, Stone and Volokh. All right, here's what they say. It's in my notes. I'm going to read it to you. The First Amendment, they say, does not protect speakers against private individuals or organizations, such as private employers, private colleges, or private landowners. The First Amendment restrains only government. That requirement has come to be known as the state action requirement. The First Amendment limits government. It does not limit what private entities can do. Now, Twitter, as you know, kicked President Trump off following the election in 2020, November 2020. Some people said that violates President Trump's First Amendment right to speak. Well, that's a mistake. Twitter is not the government. Twitter is not an agency of the state. Twitter is not a state actor. So whatever complaints President Trump has about being kicked off Twitter, one of them is not that his First Amendment right to speak has been violated or infringed. Okay, that's clear. Volokh and Stone, these prominent scholars, and both of them, by the way, are specialists in the First Amendment. That's their specialty within law. And they're telling you point blank that private entities are not subject to the First Amendment. Now, I have another example of this. Many years ago, 4 years ago, almost to the day, 4 years ago yesterday, in fact, February 21st, 2018, the owner of the Dallas Mavericks basketball team, which is in the NBA, and you probably know who I'm talking about, Mark Cuban. He's on TV a lot. He's on the Shark Tank show on CNBC, which I would recommend. Very interesting show. I watch it sometimes. Mark Cuban is the owner of the Dallas Mavericks. 4 years ago, he said publicly that his team should tank. Now, what he meant by that is his team was not in a position to make the playoffs. So what he was saying publicly is the team should lose on purpose for the rest of the season. Why? Because the worst team in the league gets the first draft pick. And that can turn a franchise around instantly. We've seen that happen. Even if you just get the second or third pick, that can change the fortunes of the team very quickly. So, whatever you think about that idea of tanking, Mark Cuban was fined, get this, $600,000 by the NBA simply for saying that his team should tank. Now, let me back up and make sure you understand this. Mark Cuban said something. Because of what he said, he was fined over $500,000. Now, obviously, he wasn't happy, but he did pay the fine. By the way, I'm reading a little further in this ESPN article. The commissioner of the NBA said in a statement that the fine on Cuban was for, quote, public statements detrimental to the NBA, unquote. Now, there were people who said, following this incident, Mark Cuban's constitutional rights have been violated or infringed. The people who said that are ignorant of basic civics. They don't know that the NBA is not part of the government. It's not run by the government. The government has no control over the NBA. Therefore, whether the NBA acted properly or not in accordance with its own rules, it has nothing to do with the First Amendment or the 14th Amendment. So Mark Cuban perhaps had a basis for complaining about this fine, but his complaint would not rest upon his constitutional rights being violated. That's entirely irrelevant to this issue. Now, you may recall that there were protests in the National Football League in recent years. Certain players were, the NFL has certain rules about what players can and cannot say, whether they can take a knee on the football field and so forth. And there were certain players who said that their First Amendment rights were being violated by the NFL. Again, that's ignorant. That could be said only by someone who's ignorant of the basic workings of our constitutional system. Okay, the NFL is not an arm of the government. Again, whether the NFL should have been doing that, that's a separate question. What I'm saying is nobody's First Amendment or 14th Amendment rights were being implicated, much less violated, by that action of the NFL. Okay, do you know that some universities and colleges are public and some are private? UTA is part of the state of Texas. It's an agency of the state of Texas. My salary is paid by taxpayer dollars, ultimately, and by student tuition. So all of the components of the University of Texas system are public. And therefore, since they are part of the state government, the First and 14th Amendments apply to all of those who work for those universities. So I, as an employee of this public entity, the University of Texas at Arlington, I have First and 14th Amendment rights. And they could be violated if my university took action against me, if my university fired me because of something I said, if the university tried to demote me in some way or punish me in some way for something I said. I could sue UTA and claim that my First and 14th Amendment rights have been violated. And that's true of any employee, not just professors, of a public university. Now, what about a private college? If a particular college or university derives all of its funding from private sources and none from public sources, then it is not a branch of any state government. And if that college or university stifled or censored people's speech or punished people for speaking, then that would not raise First Amendment or 14th Amendment problems. So whether employees of a university have First and 14th Amendment rights to speak depends very much on whether that university is public or private. Once again, Professors Stone and Volok say the First Amendment restrains only government. Now, in the case we're about to discuss, starting Thursday, Cohen was arrested and tried and eventually convicted for speaking particular words, uttering particular words. So there's no question that the First and 14th Amendments apply to him. He had a First Amendment right against the federal government and a 14th Amendment right against the state of California to not to restrict or punish his speech. And he eventually had that right vindicated by the U.S. Supreme Court in this famous case half a century ago. Okay, now what are the ways in particular that a state or governmental entity, including the federal government, can abridge the right to speak? Well, the two main ways are censorship and punishment. And as you can see at the bottom of my page 3 and the top of page 4, these are very different. Censorship means stopping people from speaking or preventing people from speaking before they even speak. That's called censorship. The other way is to let people speak and then punish them in some way as a result of what they said, because of what they said. So let's turn to page 4 near the top and look at the meaning of the word censorship. I'm going to give you a general dictionary definition and then a legal definition. Remember, both of these would be violations of the First and 14th Amendments. The general meaning of censorship, when used as a noun, is this, quote, the practice of officially examining books, movies, etc., and suppressing unacceptable parts. So notice, this act of censorship occurs by definition before the speech occurs. It's as though, imagine a regime, a situation in which before a book is allowed to be published, it must be approved by agents of the government. And they're often called censors, C-E-N-S-O-R-S, censors. The censors can examine the book and either approve its publication or disapprove and say, no, it may not be published. That would be an act of censorship, right? Where you're preventing something from being spoken or written or released to the public. Now here's the legal definition of the word censorship. It's from Black's Law Dictionary, 1979. Censorship means, quote, review of publications, movies, plays, and the like for the purpose of prohibiting the publication, distribution, or production of material deemed objectionable as obscene, indecent, or immoral. Such actions are frequently challenged as constituting a denial of freedom of speech, of press and speech. So that's the legal definition. Once again, censorship means examining the utterance before it is publicized, and deciding whether to allow it to be publicized. Now, this case did not involve censorship. Cohen wore his jacket. On the back of his jacket, he had the words F the draft. And the word that I'm calling F was spelled out. And I think you know what word I'm talking about. I don't see any need to say that word. It would just be for shock value. He had written or had worn a jacket on which someone had written, maybe not him in particular, but some friend or somebody had written, F the draft. He went into a courtroom, as you will see when we look at the facts next time. I don't know why I'm still holding this up. But he went into a courtroom and he was eventually arrested for wearing that jacket. He wasn't censored, he was punished after the fact. So he spoke and his speech was punished. Censorship means you weren't even allowed to speak. Now, we can imagine the facts have been different. What if Cohen was walking up to the courthouse and had started walking up the steps to go into the courthouse? What if a security guard or police officer saw what was on his jacket and said, excuse me, you cannot go into the courthouse with that jacket on, with that phrase, visible? Cohen may have said, why not? At that point, the officer may have simply arrested him or physically stopped him from going in to the courthouse. If that occurred, that would be an act of censorship. They have stopped him from speaking, from going into the courthouse with his jacket on and that phrase visible. Now that's not what actually happened. I'm just imagining that had happened. That would have been censorship. What actually happened was not censorship, it was punishment. He was punished, he was convicted and punished. He eventually won the case on appeal to the U.S. Supreme Court. And so his conviction was reversed and the punishment would have been nullified. At any rate, I've reached the point in my lecture notes where I plan to get today. We're an hour and 10 minutes exactly into the lecture, which is about right. I propose next time on Thursday to pick up where we just left off in my lecture notes, and I'd like to get, if possible, to near the bottom of page 7, up until Justice Harlan's majority opinion. So we have a few more items of background, legal, philosophical, historical background, and also we'll talk a little bit about the facts of the case. We need to be clear on what happened in this case before we look at the reasoning of the majority and the dissent. So we're making good progress. We have 2 more days on this case. The second of the 3 days will be Thursday, and that will be a recorded lecture, which I will post on Canvas. The third and final day on Cohen will be live in the classroom. That's a week from today. So 2 of the 3 days will be recordings, and finally we'll wrap it up with a live lecture on this famous case, Cohen versus California. Okay, make sure before you watch my lecture Thursday that you've read the entire case carefully, and then my lecture should make more sense to you. Have a great day and a great tomorrow, and I guess I'll see you, so to speak, on Thursday afternoon after I record your video for that day.